We're going to be having a tough conversation this morning because there is a petition for the removal of the Chief Justice, Gertrude Torkonoo. Article 146(1) of our Constitution has what it says about the removal of a Chief Justice and, in fact, other members of the judiciary. But why? What has triggered this petition by Professor Akufo-Addo? Well, we'll get into the details with our guest, Amanda Clinton. She joins the conversation. She is a lawyer. Amanda, good morning.
Good morning.
It's a pleasure having you one more time on the AM show. Let's start from here. Were you surprised? Were you taken aback when you saw this petition?
I wasn't surprised given the political climate, and it seemed that, with the change of government coming, it was obvious that some heads would have to roll potentially.
Some heads would have to roll, but there's security of tenure when it comes to the judiciary, especially in the case of the Chief Justice, the justices of the higher courts, the High Court, the Court of Appeal, the Supreme Court. They have security of tenure, and it's only retirement, usually, that would force them out, unless some egregious activity has been engaged in, for which reason they may merit being removed from office. So I don't know, when you say with the change of a regime, you probably would expect a change in those as well. What is the basis for saying that?
Well, I think that Professor Asari has gone to great lengths to present his petition in stating, alleged stated misbehavior and incompetence. And he does so because it is accepted that this is a rule that one cannot get, rid of the person as, the Attorney General you can get rid of at the end of the term because it's a change of government. This is not that kind of rule unless exceptional circumstances exist. And so the professor seems to have outlined some three key areas that the Chief Justice shouldn't have had a direct role in recommending individuals for appointment or promotion, and he does so in paragraph 23. He also says that, she appeared to be reconstituting panels in terms of, Supreme Court panels for particular cases with no explanation and no public interest. He says so at paragraph 24. And he also highlights that in terms of practice directions issued, they were neither issued by the Rules of Court Committee or by constitutional instruments. And that's at paragraph 48. I don't agree with him in relation to the amount of judges because I think
let's take it step by step. I've got the portions that you made mention of, but I also want us to, if possible, splash the petition on the screen so that our viewers can also, follow along with us as I read certain portions. But I'll just start reading. So it talks about, it's dated yesterday. It's addressed to His Excellency, the President of the Republic at the Jubilee House. And it reads, petition for the removal of the Honorable Chief Justice of the Republic of Ghana, Her Ladyship Gertrude Torkonoo, pursuant to the provisions of Article 146 of the 1992 Constitution of the Republic of Ghana. And I'll just read a few choice portions before we get into the salient matters, the nitty-gritty. Now, Professor Stephen Kwaku Asari, a citizen of the Republic of Ghana, respectfully submits this petition to Your Excellency, the President of the Republic, seeking the removal of Her Ladyship Gertrude Torkonoo, the Chief Justice of the Republic of Ghana, on grounds of 1, stated misbehavior, and 2, incompetence. Stated misbehavior and incompetence. Then he says, the legal basis for my petition is Article 146(1) of the 1992 Constitution of the Republic of Ghana. For the avoidance of doubt, my petition focuses on stated misbehavior and incompetence related to the Chief Justice's administrative functions as head of the judiciary responsible for its supervision and administration under Article 1254 of the Constitution. He adds, my petition, and I'm just giving those salient bits as a background so that we understand from there as we lay the foundation. My petition does not arise from the Chief Justice's exercise of her judicial functions. So administrative functions, not judicial functions. Then he goes on to say, let me just get back to where I was. Yes. Accordingly, the petition does not challenge any decisions, orders, or directives issued by the Chief Justice in the performance of her duties as a Justice of the Supreme Court, including those made to enforce judgments, decrees, or orders in cases she has adjudicated. I fully understand, respect, and value the importance of decisional independence. It is my understanding that upon receipt of this petition, Your Excellency shall, and we know when legally shall is used, what it means, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom you shall appoint as chairman, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers, and that is referencing Article 1466 of the 1992 Constitution. And it goes on and on. I think I've laid enough of a background to this matter, though he goes on to talk about inquiring into the petition and recommending whether the Chief Justice ought to be removed from office on the grounds of this petition. Now we can continue with the other salient points. So this is the thrust of the petition as far as a basis is concerned. Stated misbehavior and incompetence. Now back to your point. You were saying that you disagreed on some points.
Yes, I do. I mean, the professor, of course, makes a very strong submission based on brazen constitutional violations, abuse of office, reconstitution of panels and transfer of judges, as well as disrepute and, conflict of interest, as well as acts of incompetence, etc. And he will have to make a strong case because it is not taken lightly that a Chief Justice can be removed. I don't believe that she will be removed under this current administration because, although we do have the separation of powers, it seems by public opinion and by the strength of this petition, the petition is being brought because it hints that there wasn't too much separation of powers in terms of how much the executive have an influence, etc. But in fairness to the Chief Justice, who I greatly respect, in fairness to her, I think she has had a very difficult time just because of the heavy influence of the executive. And in some instances, she has shown exceptional leadership. For instance, with this court case that happened, or with the Supreme Court cases on the 5 judges, yes, they did rule that the seats shouldn't be vacated. But if you analyze the ruling more, the subtlety of the ruling showed that there were no court orders attached. So although it seems that there was a lot of pressure on the judiciary, the fact that for the final order, they didn't attach any orders and didn't compel the Speaker to act just shows perhaps the climate of pressure. And yet she, in that instance, chose to not attach any orders, which is something that we could give her. On the one hand, I mean, I don't agree with the professor about the choosing of or the letter that she wrote to the president, or 2 letters she wrote, and she had been told that, this should have been done in consultation. And, the letters she wrote didn't hint that she'd already sort of taken a decision. It kind of made it seem like it was just the president's idea. I don't think that would be strong enough
which would then insinuate or suggest undue influence from the end of the executive on the judiciary, countering the angle of judicial independence and the separation of powers. That is where the problem is.
Well, that is what the professor is saying the problem is. But as we all know, you do need to give a summary of who this judge is and what their qualities are, etc. So she could have overstepped her boundaries. in that sense. But again, she's also giving a summary of who these judges are. Where she might not be able to win in terms of, should a panel be convened, etc. Where I think she's going to struggle very much is this reconstituting of panels with no explanation and no public interest, because he really does cite some very strong cases that I think he's made the case. So I wouldn't go about with the Supreme Court, with the justice's recommendation, but I would say that, it was arbitrary, perhaps, it could be said, in terms of her decision to reconstitute panels when it was practically in the middle of the trial. I don't think the current president will look at this petition. Maybe he'll make excuses that, his term is nearly ended, etc. But the next administration would certainly look at such a petition, even if it is presented by another person or the same person. And in all fairness, it does look like she will be removed based on the fact that the reconvening of panels, it would appear to be unconstitutional from the facts the professor gives and from the constitutional citations he makes.
Okay, so pause for me right there, Amanda. You say on the back of the reconstitution, it does look probable that she could be removed. Of course, here we are not serving as a court. Of course, you are espousing your opinion and you are espousing whether you think there could be evidence that suffices to remove her. Mind you, these sessions will be held in camera, by the way. She could choose her own legal representation or otherwise. But I just want to reiterate, are you suggesting that on that point, she could be removed on that point? Is that what you're saying?
She could, because, for instance, if we go to paragraph 37 of the petition, where he cites that lawyer Samuel Kudjo objected, and this is in relation to the Dr. Opuni appeal. He says at paragraph 37 that lawyer Samuel Kudjo objected to the new panel, citing Article 1573 of the Constitution, which stipulates that a judge or panel cannot withdraw from a case after hearing arguments until judgment is delivered. And yet we saw that, she seemed to think that she had the administrative authority to reconstitute a panel in that case.
Right.
He also goes on at paragraph 40 to state that the power to dispense with court panels at will is not only unknown to the Constitution, but it is also anachronistic, antithetical to judicial norms, makes the judicial system susceptible to the abuse of powers, and erodes public confidence in the judiciary as an independent arbiter of disputes. So he's not questioning the end decisions she's making, but he's questioning whether, looking at this, could it be considered misbehavior, incompetence, and perhaps just taking her own authority, which again, a panel will have to decide on.
Right. Just a quick one. When you go to the end of it, he also talks about, we consider the reconstitution of panels to be beyond the Chief Justice's administrative power and amounts to a direct interference with the impartiality and independence of duly constituted judicial panels. What is your take on this? Because that is... there's a nexus between this comment and what you just said and what he's basically positing in terms of why the Chief Justice should be removed. What do you make of this? Going forward, is it what we should adopt? Is it what doesn't already exist? Because it seems to be trite knowledge, but then again, this is the Chief Justice and some bending could be done. What do you make of that?
I think he's absolutely right. For instance, every court case that goes, that happens, it is a fair process in terms of they don't care what the case is, etc. It just gets assigned to judges, and that's a fair process because it's just naturally assigned to judges. And so once you have a case in action, and it seems that the case is perhaps not going a particular way that maybe some people would expect, and then you have this sudden repaneling of then that's where the problem lies, because it almost suggests that will that second judge be more aligned to a particular political sentiment, etc. So just for the avoidance of doubt, once a case is in action, if it's not in public interest and it hasn't been justified in terms of why you're reconvening, which is what he's saying, there was no public interest involved and the decision was just taken by herself, then it's going to be tough for her to argue, but she will be given right of audience in order to respond as to why she took that decision. And she may very well say public interest or give another reason.
All right. Let me state clearly, again, we are not a court here. We are not hanging the Chief Justice. We're just talking about the salient matters in there. Of course, a committee of inquiry will be set up if the president is minded to do so, and the law stipulates what must be done in instances like this. I mean, the OSP, for example, went through a similar system when a petition was brought for his removal. And ordinarily, this should not even be in the public foray. But it has come to us, and of course, we're going to discuss it. But then such a session, if constituted, will be held in camera. I want to know what your reaction is on that very point, because when you read points 11 and 12 of the petition, it says, the grave nature of the Chief Justice's role in requesting the appointment of the said justices to the Supreme Court became evident when subsequently social media published another letter dated the 7th of February 2024 from the Chief Justice to Your Excellency. And of course, he's addressing the president directly because the petition is to him. The letter of 7th February 2024 is captioned, brief on the need for the minimum number of 20 judges on Ghana's Supreme Court bench. In the said letter, the Chief Justice states that, quote, and sick, I write in reference to our previous discussion on the Chief Justice's proposal for an increase in the number of justices of the Supreme Court of Ghana. Kindly find attached the paper justifying the need for the request. Thank you very much. And Prof goes on to say, Professor Asari, the above quotation suggests that there has been a previous discussion on the subject between the Chief Justice and the President. Of concern to your petitioner, that is Professor Asari, is the fact that both letters, one proposing an increase in the minimum number of justices on the Supreme Court of Ghana, and the other requesting 5 specific, I'm mentioning words, highlighting words intentionally, because those are the key words, 5 specific judges to be appointed to the Supreme Court were written on the letterhead of the Chief Justice and clearly expressed itself as the Chief Justice's personal request on the matter. The letter did not refer to any consultation or involvement of the Judicial Council, that is, the Council, of which the Chief Justice is a member and within whose constitutional mandate it lies to deal with matters relating to the appointment of justices of the Supreme Court. I'll just do this final bit. 15 then says, your petitioner is further concerned by the reference to an earlier discussion between the Chief Justice and Your Excellency, the President, on the proposal to increase the number of justices on the Supreme Court. Your petitioner also notes that the question of minimum number of justices on the Supreme Court is settled by Article 1281 of the Constitution, which provides that, and I quote, the Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. Is this angle of Professor Asari's conversation watertight? He mentions the Constitution and the stipulation, not less than 9, but we don't have a cap either. So whether 20 or whichever, though reference is made to that number, doesn't necessarily suggest a wrong committed?
I don't think it does, because even though that was the heading she gave in terms of, the minimum amount required, she also goes on to state in those letters, for instance, that because, they're inundated with cases, etc., more justices would be needed. So in a practical sense, she's outlining why more justices are needed. And I think Professor Sari at paragraph 19 also says that in writing these letters, her ladyship gave the impression that the names presented to the council for approval emanated from your excellency, which then would mask her role in requesting for the appointment of the judges. So although it seems
and let's pause right there. How problematic would it be if, in fact, let's join to 19. I'll go back to 19, but let's join, is it 16? Is it 16, 17 to 19? So that it makes a lot more sense put together. The plain meaning of Article 1281 is that the minimum number of justices for the Supreme Court is 10. That is 9 in addition to the Supreme, the Chief Justice. Thus, an amendment of the Constitution is the lawful way to change the minimum, not by a private discussion or communications between the Chief Justice and the President. It is Parliament that has the power to amend the Constitution, Article 289 of the 1992 Constitution. And he says, further, your petitioner has reliable information that at a meeting of the Judicial Council held on 14th June 2024, the Chief Justice expressed her desire to increase the number of Supreme Court justices, whereupon the Council advised her ladyship to pursue broader consultations with other institutions on the matter, especially the Parliament of the Republic of Ghana. At the said council meeting, the Chief Justice did not disclose the fact that her desire to increase the number of Supreme Court judges had been the subject of a previous discussion and a communication with Your Excellency. Do you get the point there? So she did not disclose at this meeting that, in fact, there had been some prior meeting with His Excellency, the President. This fact became evident only after the letter dated the 7th of February 2024 from the Chief Justice to Your Excellency appeared on social media. It follows from these facts that the Council had no knowledge or involvement. It goes on. And then you can marry it to 19, what you're stating now, where he says, in any event, your petitioner has reliable information, that is, has reliable information that on the 24th of June 2024, the Council met once again, and her ladyship then presented the names of the 5 justices for the Council's approval. In so doing, her ladyship gave the impression that the names presented to the Council for approval emanated from Your Excellency, which then would mask her role in requesting the appointment of the judges. Back to you.
Yes, but again, perhaps that's why he's a professor, not in practice, because in practice, one would sort of understate the president's involvement in this. Because, for instance, when you're presenting a petition to the president, is the president likely to implicate himself by saying, oh, yes, she really shouldn't have had those discussions with me. And then I took a decision on this, etc. You see what I mean? So there's a bit of a subtlety in practice of,
where the subtlety in practice means what? A deviation from what the letter of the law states in terms of procedure? Does it give malleability?
For instance, is the president with this petition that implicates him, at least twice, likely to refer this to the Council of State? Is it human nature to do that? Do you see what I mean? So, on a practical level, all I'm saying is that it's a very strong petition, but it is likely to be dealt with by another administration who might look at this, from standing back looking at this. But if he's basically implicated the president and said, well, she had private discussions with you, and then, went to go and present this letter as if it was coming from you. Do you know what I mean? It will be very difficult, I think, for the current president to refer this letter to the Council of State, just because, in a way, he's implicated. I also
the law states when these petitions come through what processes ought to follow, which is why I'm also referencing what happened with the special prosecutor and when there was a petition against him. And indeed, the processes went through, but he was found not to have breached, what was said of him, which would warrant any removal of that instance. Anyway, let me also, but Amanda, just hold for me.
I don't think he will hang her on this because it would be unfair, since it would be suggested that perhaps, there was a lot of influence. And so then you can't just leave her hanging and saying that, she should be referred. I do think this petition has a lot of strength when it comes to reconstituting panels, and that perhaps the subsequent administration would definitely look at this as well as, refer it to the Council of State. But in my opinion, I don't think this president will address this petition, no.
Hold for me, Amanda. We have Frank Davies. He's a lawyer. He joins the conversation. Mr. Davies, good morning. Good morning, Mr. Davies. Do we have Frank Davies on the line? Hello, sir.
Hello. Good morning.
Okay, I can hear you now.
Yeah.
Okay, there seems to be a bit of an echo. I don't know where you are, but if you could just reposition yourself. Hello, sir.
Yeah, is it better now?
It is. Thank you. Much better. I'm sure you've cited this petition calling for the removal of the Chief Justice Gertrude Torkonoo. And I would just like to find your brief thoughts about the petition and how worthy it is, how much weight it carries. That is, if you've read the entirety of the petition, before we move on.
Thank you very much. And once again, a very pleasant morning to your cherished viewers and listeners. And thanks for the opportunity. Yes, I saw it very late last night, and I decided to read all. It's about 100 and almost 19 paragraphs, if I'm not mistaken. But no given. I mean, Professor Azar has been in the legal space for quite a reasonable period of time now, and he's a trained lawyer too. And of course, it is his constitutional right. If he thinks that the Chief Justice has done something which, in his estimation, warrants impeachment or removal from office, this is cause to carry. I mean,
you sound as though you fundamentally disagree.
The reasons are one of stated misconduct, and then the second one is incompetence. So,
stated misbehavior.
It is early days yet. I certainly cannot pass judgment on what he has put out. I've read the whole petition. He makes a lot of allegations or accusations, whatever you tell it, and it is not just a catch and buy situation. I mean, we know what we have to go through, also the way that the threshold where a prima facie case will be made before.
Right.
So let's see how it rolls out.
And I get that point you make. Of course, you must establish a prima facie case before proceedings can follow. You must show that on the face of it, there is enough substance to go into the matter. Now, I am glad you have read the entirety of the petition. And I want to ask you, if you look at point 20, he makes mention of the fact that the Constitution requires the President to act on the advice of the Council in consultation with the Council of State when nominating Supreme Court judges for parliamentary approval. The Chief Justice's elaborate scheme, he calls it scheme, of requesting the President to appoint specific judges and later presenting these names for the Council's approval subverts the constitutional scheme and converts, and you understand, I mean, you're a lawyer, so you know what conversion here means, both the Council and the President into rubber stamping her preferred judges. As it turned out, this scheme was fortuitously undone by the Council's concern about the timing of the nominations. When the petition is being considered at any stage, members of the Judicial Council will be subpoenaed to testify on the matter. So let's stick to this angle for now. He talks about the fact that there had been prior conversations, about twice, with His Excellency the President, before the communication came to the President, or from the President to her, and then the other processes were triggered. He's basically talking about breaches in process and how, as we all know, it appears in this instance, the processes were being subvented and her will, through the President, was being done. What do you make of this?
Ewan,
this is Benjamin, by the way. My name is Benjamin Akakpo.
Oh, Benjamin, sorry. Your voice just sounds like you want Spencer. Sorry.
Yeah, people say that.
Benjamin.
Right.
Why don't you get that referral? Don't people tell you that your voice?
I get it all the time.
Anyway, well, these matters have been in the public domain for quite some time now. It's not new. And, I mean, the Chief Justice has given her reaction when the matter cropped. And even the Attorney General of the Republic presented a paper on the matter. At our just ended bar conference, the President spoke to the issue. So I don't want to be seen to be commenting on what is before the President. A petition has been sent. I can only talk on the general, not the specifics. This is the allegation it's making. It is up to the President to do the needful. And like I said, at the end of it all, there has to be a determination of a premier facie case before even the Lady Chief Justice will be called upon to provide her response. So I wouldn't want to be judgmental. I have my own views about the matter, but I think that it's too early for me to be passing comments on the matter, which is before the President.
Okay, so I completely understand. Before you take leave of us, though, the other angle to this has to do with the arbitrary reconstitution of panels and transfer of justices. And let me just say that I completely understand why you don't want to go into the substance of some of the matters, because the prima facie case must be established before even other processes follow. But on the arbitrary reconstitution of panels and transfer of justices, you've read it already, so I will not belabor the point. He also says, Professor Asari says, we consider the reconstitution of panels to be beyond the Chief Justice's administrative power and amounts to a direct interference with the impartiality and independence of duly constituted judicial panels. So like he said, he's not questioning her judicial, work. He's questioning her administrative work. Do you think this portion, even as it stands, some say it is clear enough. Is it clear enough, or do we need to tweak it to suit this? Reconstitution of panels to be beyond the Chief Justice. Your brief take on that, and then we can hang it up.
Honestly, when I read that part, I must confess to you, I was a bit confused. I mean, if we all agree that the constitution of a panel of the bench of the Supreme Court is a prerogative, administrative prerogative of the Chief Justice, I mean, what will go into a positive determination that a reconstitution of the panel is arbitrary, or it's been done without recourse to lay down principles, or that the Chief Justice, as it were, has been subjective and not objective in the determination of who should constitute our panel. You see, we shouldn't stretch these matters to any elastic limits. Okay? If we all agree that it is an administrative function, then the next thing is to interrogate why the reconstitution.
Right, but you say we shouldn't stretch this to its maybe logical limit. But could these powers, if not curtailed or controlled, lead to abuse, which could favor one side over another? Would you say yes or no?
Now, how is it going to be curtailed unless there's a redefinition of the Chief Justice's administrative function? But all over these years, the Chief Justice, who is the head of the judiciary and who is the president of the bench of the Supreme Court, has been responsible. Every Chief Justice has been responsible for constitution and reconstitution of panels. So I don't see how that of Her Lady Chief Justice Torkonoo becomes novel. Unless maybe my good friend Professor Azar can adduce other pieces of evidence which shows that she was arbitrary, she was capricious, she was unfair, and she applied a good judgment in what she did. But at this stage, it's too early for anybody to surmise or think that the Chief Justice has been untoward in her administrative functions. If she has the prerogative and the discretion to do that, the next one is to question what she did and to interrogate and see whether what she did was right or wrong. But that on itself, that bare assertion, cannot lead to any impeachment procedures, in my humble submission.
All right. He goes on to reference the Opuni trial and previous, of course, incidents about reconstitution and the abuse of the same bit. But let me just ask you before you take leave of us. So in addition to your final words on this matter, and while you don't want to give a verdict, Amanda Clinton on the other end says there could be some case for her removal. Is that to say
there could be what?
There could be some case for her removal. Is that to say that for you, from where you sit, having read the entirety of the document, you see no such case?
Well, I'm not Amanda Clinton.
I'm asking for your opinion. I only reference that.
Yeah, I'm saying that is a determination. All I've said is that it is early days here. I cannot be judgmental on the petition which is before the president. And we all know as lawyers that a premier facie case will have to be made before the case is made against her. So if anybody should say at this stage that she has a case to answer, that is the person's opinion. I am saying that for now, there's a petition. It has to go through a process. And then a determination is made. And she will be called upon to answer. No, I cannot, on radio or sitting anywhere, say that a strong case has been made against her. I mean, she has not been given the opportunity, if it comes to that state, for her to say otherwise.
Right.
So why would anybody say that a strong case has been made against her? I mean, which case?
No, she didn't say that a strong case had been made against her. I could allow her to clarify. All she was saying was that on some of the points, maybe there could be the possibility of that. But
that is why I'm saying that an allegation has been made.
Okay.
Whether factual or infactual is another matter. So why don't we wait for the processes to roll? Once upon a time, the same petition was brought against the special prosecutor. People make all manner of kinds of comments.
Right.
What happened at the end of the day?
Yeah.
So, let's just relax.
Right. And I referenced the special prosecutor in this. So logically, just to leave us, what processes will the president have to execute now that the petition is in his hand? Ordinarily, it shouldn't be out for us to discuss it, and even the process would have to be held in camera. But it is out now. We are discussing it. What next for the president to do in respect of the petition?
Benjamin, the president of this republic has done this over and over again. Let us wait for him to do what he should. Yeah? He has done this over and over again. This is not the first petition which has been brought before him.
Just walk us through the processes.
I recall that of Charlotte Osei, and I recall that of the special prosecutor. So let's wait. The president will do what he has to do. I cannot be seen to be speaking for the president. So the petition is before him.
Hold for me, just in case Amanda has any clarity. Amanda, do you have any clarity on the point I made? I just want you to say it before maybe Frank Davis takes leave of us. Amanda.
The point is the procedure, as in what's going to happen next?
No, on the point of what you had said, that there could be reason for her removal.
Well, I mean, again, this is a professor who's written a very strong paper that, on the face of it, he's justified with constitutional provisions, citing cases, as well as, citing what lawyer Samuel Cudjoe objected to in the Opuni appeal, citing Article 157, subsection 3 of the Constitution, which stipulates that the judge or panel cannot withdraw from a case after hearing arguments until judgment is delivered. So these are sort of questions that the Chief Justice might have to respond to should she give a defense for this. And ultimately, this is a question of reconstituting panels with no explanation and no public interest, as he cites at paragraph 24. So again, it is for her to answer the question, is there an explanation, and was there public interest involved, etc. But again, this is not a court of law. We're all just sort of giving our opinions on a very strongly and very well-written petition, which may or may not stand. Due process has to take place, and the Chief Justice's words have got to be heard in terms of her response and her defending herself, because she's a very capable, very competent Chief Justice, and this petition is before the President.
Okay. Frank Davies, thank you so much for your time with us this morning, sir. We appreciate it.
Thank you, Benjamin. Thank you.
All right. And that is Frank Davies. He's a lawyer. Amanda, do you have any final words before we proceed? I asked Frank Davies about the processes. Yes, he mentions Charlotte Osei, the former EC boss or chairperson. He mentions the special prosecutor. But what are the expectations from your end now that the petition is out?
I mean, this is a far better petition than those petitions which I also read. It's better in terms of the lengths the author has gone to in terms of bringing out constitutional provisions, bringing out case law, citing examples, and sort of harmonizing the document in a practical sense, which will give any, panel, any Council of State panel, enough to work on in terms of, should she be called before them, they will have a lot to question her on. So I think this is a stronger petition that can potentially be justified. But again, I don't think under this political climate in terms of this government, they are going to perhaps take this forward. That's just my opinion. I think perhaps the next administration might look more keenly as to whether the case of stated misbehavior and incompetence has been proven. And, it'll be a shame, because she's a great Chief Justice in terms of absolute confidence and ability. But again, she was put in a very tight position. And this is why, as the professor and everybody else will tell you, we have the separation of powers in this country, so that the executive does not have an influence on the judiciary does not feel forced to act to a certain extent, and that the Speaker of Parliament can be left alone.
Okay.
And this is what happens. This melting pot is what happens when people overreach, etc.
Right. And maybe not just influence, but undue influence. But thank you, Amanda Clinton, for joining the conversation as well. Amanda Clinton is also a lawyer and head of her chambers. Thank you for joining the conversation. So we had Amanda Clinton and lawyer Frank Davies joining this conversation.